Hello, everybody, and welcome back. This is Rachel with Justice for South Dakota, Episode 2, How Kristi Noem, South Dakota, Removes Freedom from the People and Promotes a Communistic Dictatorship. Now, you can't really understand what's happening unless you understand the basis of what gives police officers, what gives judges, what gives state's attorneys the authority to prosecute a crime. When is somebody allowed to come into your home and take your children directly from you as a parent? When is somebody allowed to come into your business and confiscate your business? So we're going to explore the legal side first. It goes all the way back to 1776. The United States issued a Declaration of Independence. The primary author, Thomas Jefferson, wrote out the document along with the assistance of the other American founding fathers, and this commenced after the American Revolutionary War. The early colonists were very tired of dictatorships, and they said that no longer were they going to be part of the British Empire. We were having a free nation under God in which all men had the equal rights. All men. It did not matter your age, race, or gender. This was followed up with the Constitution of the United States of America in 1787 AD. Now, the Constitution of the United States is the fundamental law that comprises or dictates how every single court in the United States of America, both federal and state, must operate. It is the oldest written national constitution in use, and it is the very basic, bare bones heartbeat of every single government and their jurisdictions. It stands up for the freedoms of citizens. It was further followed up by the Bill of Rights. The Bill of Rights was proposed by Congress in 1789, and it was finalized on December 15th, 1791. It limits the powers of the federal government of the United States of America, and it protects the rights of all citizens, both residents and visitors in American territory. The Bill of Rights protects the freedom of speech, freedom of religion, the right to keep and to bear arms, the freedom of assembly, and the freedom to petition. It also prohibits unreasonable search and seizure, cruel and unusual punishments, and it prohibits compelled self-incrimination. Among the legal protections that it affords, it also prohibits or stops Congress from making any law that respecting the establishment of religion and depriving any person of life, liberty, or property without the due process of law. Now, how about South Dakota? Well, the South Dakota Constitution was initiated or implemented when South Dakota sought statehood in 1883. This was the first time that the people of the Dakota Territory petitioned the Congress for admission to the Union and recognition as a state. In 1889, the Third Convention led to the final South Dakota constitutional provisions. Now, the South Dakota Constitution consists of both a preamble and then it's also followed by 30 articles. I have addressed the applicable articles here today. The preamble to the South Dakota Constitution states that we, the people of South Dakota, are grateful to the Almighty God for our civil and religious liberties in order to form a more perfect and independent government, establish justice, ensure tranquility, provide for the common defense, and promote the general welfare, and preserve to ourselves and our children the blessings of liberty. Therefore, we do ordain and establish this Constitution for the state of South Dakota. Now, remember I said I was going to do the applicable article. So Article 5 of the South Dakota Constitution is entitled Judicial Department. It contains 39 sections, of which Section 14 through 39 have been superseded. So specifically, we're now going to be looking at Article 5. Section 1, Judicial Powers. The judicial authority is granted both to the Supreme Court and circuit courts of general jurisdiction, and then courts of limited original jurisdiction, only as established by the legislator. What this means is that no judge has any authority to issue any rulings or orders unless the legislature has established a law granting that judge the authority. This is extremely important to understand because every single day in Pennington County, every single day that the judicial system is in operation, judges are stripping the general residents of Pennington County from their legally vested rights as granted by the legislature of South Dakota, and they are confiscating their personal property. They are stripping them of their rights, and they are destroying their families and taking their children away. Now, Section 5 of Article 5. The Supreme Court shall only have jurisdiction as may be provided by the legislature. The circuit courts have jurisdiction in all cases as provided by the legislature. The circuit court judges and Supreme Court judges do have the power to issue, hear, and determine cases, however, only as provided by the law. Article 6 of the South Dakota Constitution is entitled Bill of Rights. This mimics the American Bill of Rights, and it contains 29 sections. Section 1. All men are born equally free and independent and have certain rights, among which are enjoying and defending their life and liberty, acquiring and protecting personal property, and the pursuit of happiness. To secure these rights, governments are instituted among men, deriving their power from the consent of the citizens they govern, as implemented by law into the legislature, and therefore South Dakota codified law. Section 2. No person shall be deprived of life, liberty, or property without due process of law. I'm going back to the United States Constitution, which, remember, Governor Noem admitted that the South Dakota must abide by the United States Constitution, and this is in the 14th Amendment, Section 1. All persons have the right of the United States, the protections of the United States, and they are subject to the jurisdiction of the state where they reside. This is extremely important for the upcoming presentations because somebody from Florida cannot come to South Dakota and demand the jurisdiction of South Dakota. They are subject to the state wherein they live. So therefore, they're subject to Florida. Somebody from Washington cannot come into South Dakota and start demanding that stuff be done because they're subject to Washington. Only the people of South Dakota are under the jurisdiction and privileges of the state of South Dakota. The United States Constitution further says, no state can take away any person's life, liberty, or personal properties without due process of law, and no judge, no police officer, nobody can deny any person within its jurisdiction the equal protection of the laws. So there's actually two amendments to the United States Constitution. There's the Fifth Amendment and the 14th Amendment. The Fifth Amendment is for the federal, saying that the federal government must act fairly at all times. And the 14th Amendment extends that restriction to the state and local governments. So, what exactly is the due process of law that these amendments are referencing? Due process is broken down into two branches: substantive due process, which means that when the legislatures, when the House and also the Senate are talking about these laws and then they're passing them and then the governor signs it into law, that these laws must be fair. They can't be discriminatory. They cannot extend rights to a child which don't apply to the parents. They can't extend rights to a parent which don't apply to a child. They can't extend rights from one ethnic minority to another ethnic group. Everybody has to have the exact same fairness in the laws that are passed. And then there's procedural due process. Procedural due process is the regulations and rules that a government official has to follow when they take away your rights. So, for instance, you're all familiar with police officers or deputies or highway patrol, who are all government officials elected by or appointed by the state or county or, like district, depending on how high up the chain they are. But they're not just allowed to pull you over on the road. They're not just allowed to come to your door and enter your house. They have to follow procedures before they do so. They're not allowed to target you like highway patrolmen on the road. You must be violating a law. They have to have a reason to pull you over. Otherwise, it's harassment. If a law enforcement officer shows up at your door, he has to have a reason he's there. He can't just come to your door and demand entry. He either has to have a search warrant or he has to have I'm not familiar with all the exact legal terms, but he has to have a court document signed by a judge or issued as, like this is what you're being guilty of or charged with. And then when you go to court, you have to know what is the allegations against you. Why are you there? So that's what the procedural due process is. So wait, what about that lawsuit we talked about in episode 1? And remember that these episodes build on each other. You're not going to understand a future episode until you've watched the previous episodes. So if you haven't watched episode 1, please go back and watch that, because we are referencing this lawsuit where Judge Viken found that Judge Davis, State's Attorney Mark Vargo, and Department of Social Services Child Protective Services 100% of the time violated the law. So how did they violate it? Because they violated following procedural due process, both in their policies that they developed and implemented for the removal of Native American children from their parents' custody. So they also violated the Federal Indian Child Welfare Act and the state's stated legislative enacted law. They violated the Due Process Clause, both of the South Dakota Constitution and the 14th Amendment of the United States Constitution. And I've posted links to the final order that Judge Viken released so that you can go back and verify that what I'm saying is true here. This was taken word for word from page 4 of that final order. So let's explore. What are the undisputed facts? Well, the undisputed facts are, according to Judge Viken, that 823 Native American Indian children were involved in 48-hour hearings in Pennington County, South Dakota during the years 2010 to 2013. He found that these hearings lasted anywhere from 60 seconds to 5 minutes. He found that Judge Davis is the one who typically conducted the hearings within 48 hours of an Indian child's removal from their parents' care, and that the average hearing lasted less than 5 minutes. He found that the removed 823 Indian children often have to spend weeks or months in foster care away from their parents. Judge Viken further established that not only did all of those defendants violate the law, but he quoted a few other case law. So case law are how previous courts ruled on the matter. The case law that Judge Viken quoted was Troxel versus Granville from 2000. And the court found that the interest of parents in the custody and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. In other words, this has previously come to trial how many times, and the judges have always upheld that it is a parent's right to have custody of their children and also to determine how those children are raised. It is not the government's right. It is a communistic government that takes your child away and says this is how we're going to raise it, and that's exactly what South Dakota is currently doing. The Due Process Clause of the 14th Amendment protects the fundamental rights of parents to make decisions concerning the care, custody, and control of their children. And this is what Judge Viken found, that State Attorney Mark Vargo, Department of Social Services, Child Protective Services, and judge had violated 100% of the time out of those 800 kids. Moving on to Section 23 of the South Dakota Constitution, it prohibits excessive bail, fines, or cruel punishments. It specifically states that the state, or it specifically, when I say state, it directs all people in the state of South Dakota that they are not allowed to undergo cruel punishments. And this is a small picture of the trauma that a child goes through when a law enforcement officer comes at the direction of a judge in South Dakota or Child Protective Services and takes that child away and puts them into foster care or whatever happens. It's cruel punishment, especially when it's violating the law. Section 26 says how the state of South Dakota gets its authority. From the people, from the very citizens of South Dakota. All political power is inherent in the people, meaning that no judge has any authority unless it is granted to him from the people. It says that government was instituted for their equal protection and benefit, meaning every citizen in the state of South Dakota is entitled to the exact same freedoms. Just because you're a white male, just because you bribe a judge with money, you should not have any further or increased rights or protection from any other citizen. Judges should not be bought. And what I am going to prove to you time and again is that law in Pennington County is 100% bought and paid for by the white supremacist male. So it says that all people have the right to live in a safe state. It is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. So this is going back and referencing the United States Constitution, the Bill of Rights, and the amendments that I brought up at the beginning of the show. Now remember, the South Dakota Constitution had all these sections. We're now looking at Section 27. Maintenance of free government. It can only be maintained by firm adherence to justice. That's it. It's not allowed to be a dictatorship, not allowed to be a communistic country. There is zero excuse for a single verdict to be issued or order to be done unless it is a firm adherence to justice. And that's why I'm doing this presentation and this entire series, is because I'm proving to you how day after day after day the judges of Pennington County in South Dakota issue rulings taking away freedoms which are so it's unheard of. And they're doing it and giving it to the person who pays them the most money. So Article 16th of the South Dakota Constitution is entitled Impeachment and Removal from Office, and I copied Section 3. And so if a judicial officer, governor, or any other state officer, except for the police, the county judges, and the really small ranking justices, so these are people that don't really have any authority, they shall be liable for impeachment for any time it's a misdemeanor in office. However, their punishment is simply remove them from office, and they're not allowed to hold another public office because they've already been proven found in a judicial sitting. This particular one is, I believe, by the Senate. Judge Viken found those Mark Vargo and DSS people guilty. That should have been enough to remove them from office. So when you've proven beyond a shadow of a doubt that you're guilty of violating these articles, you should not be allowed to hold a public office and continue on with everything that you're doing. Kristi Noem is fully aware that her judges in Pennington County and Chief Justice Jensen on the Supreme Court are dictators. Now, a dictator is a form of government in which one person or a small group of people possess absolute power without being limited by the constitutional orders that are in place. Kristi Noem is fully aware that her leaders are violating the South Dakota Constitution and the United States Constitution, and yet she is condoning their behavior. This is why I am calling the people of South Dakota to hold Governor Noem accountable to her oath. She's the one who quoted the Constitution, Article 4, Section 3, and we're calling her to start holding her own state in accountability. There is no way. Governor Noem can be impeached because she is over everybody in the state and she's aware of these instances happening and she's doing nothing about it. So technically, the people of South Dakota can impeach her. So that's how serious this is. In the upcoming presentations, I'm going to continue expanding on why publicly appointed officials, including state attorneys, are to be tried and, if found guilty, impeached, removed from ever holding another public office, and how Governor Noem and Chief Justice Jensen are required, as the top authority in the state, to remove any person found to be violating the Constitution. Now, I don't like people who get up and just say stuff. Every single thing that I say is documented extensively and proven to be true. I'm going to explore what due process is, how it is violated every single day by the 7th Circuit and the South Dakota Supreme Court. I'm going to prove how justice, quote-unquote justice, in Pennington County is only reserved for the white male who bribes the judicial system, not ethnic minority groups or anybody else. I'm going to prove how honest people are repeatedly placed in prison for speaking out just to get them to be quiet, how their families are destroyed and their personal property is taken away and their businesses completely confiscated. Again, this is a privately funded public exposure of the perverted judicial system in Pennington County. I gladly accept all donations. However, I do strongly encourage you to donate anonymously so that you're not retaliated against. Because just from me speaking out on this topic, I have had extensive retaliation, and I'm going to go into more detail on further episodes. Again, please watch these as they're released, so they build on each other. This is episode 2. Next, you'll be watching episode 3. Thank you.